Greetings, ladies and gentlemen. I'm Mukesh Bhutani, your host. On behalf of BMR partners and the transfer pricing team members, I'm pleased to host this special webinar wherein we are going to talk about nuances with respect to amendments that have been carried out in the 2017 budget vis-a-vis transfer pricing, and in general changes as regards secondary adjustment. I'm joined by my colleagues Karishma Patarfekar, who is a partner and leader of transfer pricing practice, and Ashutosh Dikshit, an off-counsel to the firm and former joint secretary in the Ministry of Finance. In the next 1 hour, we are going to take you through the changes that have occurred with illustrations and examples, and we will leave some time for the question and answers. Very briefly, before I hand it over to Karishma, just wanted to talk about the concept of secondary adjustment, in particular changes that have been carried out in the law this year, and more importantly how it is going to impact your businesses in the future. The Finance Bill of 2017 has proposed a concept of secondary adjustment. This concept is very well known internationally and also ascribed very clearly in the OECD regulations. Interestingly, before the transfer pricing legislation of 2001 came into force, in the 1999, the committee that recommended transfer pricing law did talk about secondary adjustments. However, this does not feature in the 2001 regulation. Simply stated, a secondary adjustment is an outcome of a primary adjustment, the primary adjustment being a transfer pricing adjustment that is carried out in India, a concept that we are familiar with. And what secondary adjustment essentially means is that this primary adjustment, under certain circumstances that we are going to talk about, and there are 5 such situations, will automatically trigger a secondary adjustment. And this is now kind of mandated under the law. If the secondary adjustment is not carried out, it will result in a deemed income or a deemed transfer pricing adjustment in certain scenarios subject to conditions that we talk about. So the amendment has been carried out to section 92CE, and I'm not going to read that amendment except for saying that the concept of primary adjustment, secondary adjustment, cash have all been defined. Just as a matter of background, 2-3 developments occurred in the last few years that has made the tax administration think about this move. Number 1 being the famous adjustment carried out for Shell and Vodafone that resulted in the Bombay High Court adjudicating on the matter. In the Shell and the Vodafone case, a dispute arose whether the shares had to be issued at a particular value higher than the value at which it was issued to its foreign associated enterprise. The difference between the value of shares as determined by the tax administration and the value at which the shares were actually issued was deemed to be a loan. That is the concept of secondary adjustment simplistically stated. However, when the Bombay High Court decided the matter in 2014 as regards Shell and Vodafone, it did not go into the concept of secondary adjustment. It instead struck out the adjustment primarily because the Indian transfer pricing law mandates an adjustment to be undertaken only if there is an income arising therefrom. So it did not dwell into the concept of secondary adjustment. However, we've come across instances where the tribunals in India have had the opportunity to deal with the concept of secondary adjustment, and the most often being talked about is the case of AMP decided by the Bombay Tribunal. In this case, the tribunal categorically rejected the revenues stance insofar as secondary adjustment is concerned, arguing that the Indian transfer pricing law doesn't envisage such a concept. So with that as the background and setting the context, I will hand it over to Karishma to take us through the statutory provisions insofar as the changes are concerned. Karishma, over to you.
Thanks, Mukesh. Hello, everyone on the call. Just moving on, the proposed provisions on secondary adjustments have been introduced in a new section 92 CE. These are proposed to be effective from the first day of April 2018, which would effectively mean assessment year 18-19 onwards. Interestingly, the section starts with mandating a secondary adjustment on the assessee. So there are two conditions in the first subsection 1, which says that a primary adjustment to transfer price needs to be made in 5 situations, and it defines 5 situations, all being a mutual acceptance by the assessee. The first one being a suo motu adjustment, second one being acceptance of an adjustment by the assessee, and the third one being determination in an APA, fourth one being safe harbor rules, and the fifth one being a resolution under the MAP. So interestingly, all these 5 conditions are situations where the assessee has agreed to the primary adjustment in some form or the other, either on their own or either in a dispute resolution mechanism. It then moves on to say that a secondary adjustment shall be made, and by the word shall, as I was just mentioning, it mandates a secondary adjustment on the assessee if in one of the 5 situations a primary adjustment has been made. Moving on, there is a proviso to the subsection 1 which excludes applicability of the secondary adjustment if 2 conditions are met. And primarily these 2 conditions are the primary adjustment does not exceed INR 10 million, and if the primary adjustment is made in respect of assessment years commencing on or before the first day of April 2016. So essentially there are 2 conditions here. One, if it does not exceed 10 million or 1 crore INR and it is pertaining to a previous year beginning 1st April 2016, which means for financial years before 15-16, and if both these conditions are satisfied, then the assessee would fall under the proviso, and having fallen under the proviso, it would be excluded from the mandatory requirement of making a secondary adjustment. This is a very interesting provision because the way the section is worded, it could lead to a lot of interpretational issues which we would be dwelling upon in our FAQ section of the webinar. Moving on, subsection 2 of 92 CE mentions that a secondary adjustment needs to be introduced only where a primary adjustment results in increase in total income or reduction in a loss. So this is really to bring it in line with the provisions of section 92 subsection 3, which also have a similar provision that you can't make a downward transfer pricing adjustment. So if the transfer pricing adjustment is favorable to the assessee, then of course the secondary adjustment does not get triggered in. And the other portion to the subsection 2 mentions that the excess money, which is available with its AEs as a result of the primary adjustment, if this is not repatriated to India within the prescribed time, then this excess money will be treated as a deemed advance, and interest will have to be computed on this deemed advance in the manner that the rules will prescribe. So here we are looking at bringing in specific rules on 2 things. One is the time period within which this money needs to be brought into India, and second is the manner of computation of the interest, which would be what is the interest liability, interest rate, etc. that may come out in the rules. one must, pay attention to this, that this particular provision does not, exempt or does not give a kind of a leeway or a safe harbor to the taxpayer to not determine what is an arm's length interest rate. So when, there are two things. One is what is the arm's length interest rate, and second is, the period of computation. Now both these in the normal parlance, you would ideally have, done some analysis to determine what is the appropriate arm's length period for a particular industry, or what is the arm's length interest rate for a particular industry, or a situation or a type of a loan. But in this situation, really the rules, the provisions is saying that this will be prescribed in the rules. So I don't think really the assessee will have an option really here. The mechanism will be defined in the rules, like you have, in the safe harbor provisions for interest. So it would be interesting to see what they come out in the, rules. Moving on, 92 CE3 then goes on to defining certain terms. The terms that have been defined in 92 CE3 are what is an AE. An AE basically is given to have the same meaning as section 92A subsection 1 and 2. So the normal meaning of associated enterprise that we have been used to taking, while inferring whether there is an associated enterprise in our transfer pricing studies, is what we need to look at even in this case. What is an arm's length price? Again, it is the same meaning as assigned to under section 92F subclause 2. Moving on, excess money. What they define excess money as the difference between the arm's length price determined in a primary adjustment and the price at which the international transaction has actually undertaken. So till date really, there was no provision under the transfer pricing law as to how this difference should be treated, the difference between the ALP and the transfer price. What the secondary adjustment is trying to do is to say that this difference, which is the excess, is really the second leg of the transaction, and if this is not repatriated into India, then this needs to be treated as a deemed loan. Then it defines what is a primary adjustment, and it also defines what is a secondary adjustment. A primary adjustment is essentially the transfer price determination in accordance with the ALP. Again here very clearly where they mention that has an impact on resulting in the increase in total income or reduction in the loss. So an adjustment which is in favor of the revenue and not in favor of the taxpayer, that has been proposed by the assessing officer in the regular transfer pricing proceedings would be a primary adjustment. And last, it defines what a secondary adjustment is, which is what just Mukesh explained, that it means an adjustment in the books of the assessee and its A's to reflect the actual allocation of profits between the group entities in a consistent manner as determined, which results from a primary adjustment. So essentially, here again, secondary adjustment, is something that you're saying that you need to make in the books of not only the assessee, but also the AE. And this is again an interesting question that we will deal with when we come to our FAQ session. So these are in summary the provisions on the secondary adjustments, and I will now request Mr. Dikshit to take us through some of the global practices and the OECD guidelines on secondary adjustment.
Thank you, Karishma and Mukesh. And so the interesting thing is that secondary adjustments are talked about in the OECD guidelines under the chapter 4, which is administrative approaches to avoiding and resolving TP disputes. The guideline accepts the fact that by making a primary adjustment, you do not still ultimately achieve an arm's length objective, because
despite having made the primary adjustment, the transaction itself has not been followed up by a cash repatriation, and therefore it does not reflect, the adjustment is not reflective of what is consistent with the result that would have arisen if the controlled transactions had been undertaken on an arm's length basis. It then talks about secondary adjustments and how this particular thing can be dealt with either by deeming the primary adjustment, the secondary adjustment arising from it, as a constructive dividend, as a constructive equity contribution or capital contribution, or as a constructive loan. It also talks about the fact that Article 9.2, which is the standard Article 9 on dealing with associated entities in the model DT80 provisions of OECD, it says that under Article 9.2, countries are not required or not obligated to give corresponding adjustments which result from secondary adjustments. Now, if you're not going to give a corresponding benefit as a result of a secondary adjustment, it is going to lead to a situation of double taxation. That is why actually this is covered under Chapter 4, Administrative Approaches, because essentially the OECD guidelines admit that the only way to take care of a double taxation situation arising from secondary adjustments is through a MAP process. So my first reaction to the proposed secondary adjustment provisions in the finance bill is that it is going to lead to a re-evaluation of taxpayer situations about when and at what time should they approach for dispute resolution under MAP. As far as the global provisions, how the secondary adjustments have been addressed in other jurisdictions, you will see that a majority of the countries, in fact all of them, if you look at the stars, is that the deemed dividend approach has been followed in most of the countries where secondary adjustments are being handled. The finance bill, however, approaches this from a constructive loan concept. Now, the only jurisdiction which has used the constructive loan as the basis for the secondary adjustment is South Africa. However, in 2015, the South African legislation was amended to also, in their case, bring the secondary adjustments in line with a constructive dividend proposal. And that is because they faced a number of administrative situations regarding the computation of interest, regarding the capitalization of interest, regarding the rate of interest, and having faced that, they have taken a decision that they would still want to hold on to secondary adjustments, but want to take it into a regime of a deemed dividend kind of situation. The United Kingdom has floated a consultation paper in which they have again proposed a constructive loan approach, the same as what is there in the Finance Bill 2017. In their case, they are still waiting for inputs, and what finally they take as a position with regard to secondary adjustments, whether they want to take the road of constructive loan or whether they want to treat it as a deemed dividend, that is still to be decided by the tax authorities in UK. So if we come to this particular chart, then India is the only country which will currently have a constructive loan kind of a proposition in secondary adjustments if the provisions of the Finance Bill get enacted in the Finance Act 2017. So if I would say in a gist, the OECD guidelines do accept the fact that a secondary adjustment may be needed if you really want to follow an arm's length principle right to its logical conclusion. The commentary but also talks about the fact that why so many countries still do not attempt to do it, because according to the commentary there are so many complications which then arise on account of doing these secondary adjustments, and those are both accounting complications as well as complications in other legislations of that country. It also emphasizes that there is no obligation on the other country to give a corresponding adjustment account of a secondary secondary adjustment kind of situation, and therefore the only resolution of this would be under a MAP process. So with that brief about how the global position is with regard to secondary adjustments, I'll hand it over back to you, Karishma, to look at the practical issues and the FAQs.
Thank you, sir. One interesting point that Mr. Dixit made was, on the OECD commentary. And, we have annexed in our slide deck on slides 32 and 33 the relevant OECD provisions. And as Mr. Dixit rightly pointed out, the Article 9.2, which is, the OECD refers to the commentary on Para 2 of Article 9 of the OECD Model Tax Convention, and it definitely notes that this article does not deal with secondary adjustment, and it neither forbids nor requires the tax authority to make secondary adjustments. So it will also be interesting, to see, as he rightly pointed out, that how these resolutions take place going forward, and which is what we will deal with in our practical issues section that we plan to cover now. I think since we've delayed this discussion on secondary adjustments since the time this was announced in the finance bill, because really in the last 2 weeks, we had a number of queries flowing in from our live practical client situations that we were dealing as advisors, and which is why we thought, we should dwell upon some of these contentious issues in the form of a webinar for the benefit of the larger audience here. And one such interesting question that most of our clients have come back to us with, which is covered on slide 15, is really as to whether a secondary adjustment, what is the period as to when the secondary adjustment is required to be made. Is this provision really retrospective, or is it, proposed to be applicable only prospectively from FY 16-17 onwards? The way the proviso to section 92C of the Act reads is it excludes, a secondary adjustment to be made in a situation where two conditions are satisfied, which I had just discussed about. And in light of this proviso, which uses the terminology and between these two conditions, Mukesh, it would be interesting to understand your view, being, one of the leading legal experts in the country, as to what is your interpretation of, this particular section, and what do you think, as to whether it would be prospective or retrospective?
Well, Karishma, there is a drafting error which has led to this interpretation, and I'll just explain to you why. The new provision on secondary adjustment is actually a charging provision undoubtedly. Why do I say it's a charging provision? It's a charging provision because it brings to charge a transaction which is the interest, and the manner in which the interest has to be computed is yet to be prescribed, in relation to a deemed loan, and the deemed loan arises if the secondary adjustment is not carried out. So let's envisage a situation where a taxpayer has a primary adjustment in India, which automatically leads you to a secondary adjustment, which means you have to remit that money into India by way of a loan, and if you do not remit that money by way of a loan, it deems another adjustment, which is the interest or the rate of return on that loan. So it's a charging provision, and the charging provision will not have retrospective application unless it is specifically been provided in the law. the law is very clear that the primary adjustment has to be made in respect of an assessment year commencing on or after the 1st April of 2016, which means assessment year 18-19, i.e. transactions from April 1, 2017. I guess the suspicion and doubt has arisen because the lawmakers, instead of saying where a primary adjustment to transfer price, they should have said a primary adjustment to a transfer price in relation to an international transaction entered into from April 1, 2017. So yes, the manner in which the law has been worded leads us to two interpretations, whether it is retrospective or it will apply prospectively. My view is that purposive interpretation means that it will apply prospectively. However, insofar as the retrospectivity is concerned, there are two possible scenarios that are coming in. Scenario number one, for transactions that have been completed for the financial year 16-17, on which the compliance will happen only in November. So let's go to the 5 scenarios that you talked about that result in a secondary adjustment. And I will just pick up one of the scenario where a primary adjustment has been made suo motu by the SSC. So let's assume an SSC is complying with his requirement for 16-17. He carries out a suo motu adjustment. He has to carry out a suo motu adjustment only in the month of November. Now when he carries out a suo motu adjustment, will it mean that it will trigger off a secondary adjustment? If I apply the retrospective principle, the answer to that is a clear yes. The second scenario where a retrospective application of secondary adjustment law will occur will be when an adjustment is done by the assessing officer, or there is an advance pricing agreement which has been determined by the AP authorities, or if the taxpayer carries out a safe harbor adjustment. So all the 5 scenarios that are envisaged where a primary adjustment can occur can result in a retrospective application. Having said that, I feel that because this is a charging provision, it will not apply retrospectively, but there is something that needs to be done to carry out a change in the wording of the law, because the law as it is worded today clearly leads us to believe that this could have a retrospective application.
So let me add, this is Ashutosh, let me add something here, Mukesh, that one of the aspects of retrospectivity you have dealt with, and you've talked about that this is the finance bill situation, and therefore at the level of the Finance Act this particular clarity should come in. But there's another one which I think that has been put in specifically, where essentially we are talking about the current year financial year 16-17. Now the current financial year 16-17 is assessment year 17-18. As you mentioned, the return filing will be in November. Now for that, for the current ongoing year, the provision seems to suggest that although it is applicable from assessment year 18-19, the way the proviso is worded for assessment year 17-18 also, when closing the books of accounts and when doing the transfer pricing analysis, a primary as well as a secondary adjustment will have to be done. Now at that point of time, which is anywhere between June and November when this will have to be done, you will therefore need to know from what date does that constructive loan start, what is the rate of interest of that constructive loan, in case you want this to be repatriated to India and therefore not trigger an interest charge, by when it has to be repatriated. Now all of these are currently in the realm of possibilities, because this is supposed to be part of the subordinate legislation which is the prescribed rules. So therefore best practice in terms of prospectivity would have been that this should have applied only to international transactions in relation to assessment year 18-19 and future years. It should therefore have also excluded assessment year 17-18. We will, of course, when we go back to the government and give the representations on behalf of clients, will specifically mention this and ask for a true prospectivity of this legislation and not retrospectivity as well as any kind of retroactivity, as I explained.
Thank you, Ashutosh.
Okay, so that's an interesting conclusion, Mukesh and Mr. Dikshit. And both your conclusions are leading to a view that this should be intended to be applied prospectively and not retrospectively. And just to, throw light on a similar provision in transfer pricing, when the DRP provisions were introduced and Section 144C was introduced, there was this debate on what is an eligible assessee, and the conditions mentioned were in terms of where a transfer pricing adjustment is made and it's a foreign company. So at that time also there was a lot of litigation as to only when both these conditions are satisfied can you go through a DRP route. But the courts ruled, or the tribunals ruled, to say that no, both these conditions, though the word "and" was used in between the two conditions, should be read as separate categories of assessees and not as cumulative, meaning transfer pricing adjustment and a foreign company. So I think going by that and going by the intention also that comes out in the notes to clauses, I think the intent is very clear that it needs to be prospective. But as Mukesh, you rightly pointed out, it's a drafting error, and few changes may have to be made, and Ashutosh sir is making adequate representation for that, and we hope that this will be clarified when the final act is passed. So moving on to the second question, really again this is dealing with again legal interpretation, and Mukesh, you would need to throw your legal hat here to really answer this question as to, will a secondary adjustment be made if an appellate authority upholds the primary adjustment? Now really the question here, Mukesh, is that, the subclause 2 of 92 CE1 says that the adjustment is made by the AO has been accepted by the assessee. So what would that really mean? Would it mean that if the assessee decides to appeal against an assessing officer order, then a secondary adjustment would not kick in? Or would it mean that even if the assessee appeals against the assessing officer order, but at some stage in appeal, it reaches finality, and then the assessee finally accepts the outcome and pays tax on it, that would mean deemed acceptance, and therefore a secondary adjustment would trigger in. So what are your thoughts really, Mukesh, on this particular issue?
Karishma, I'll answer it. There are two possible interpretations, but this time I am going to take the interpretation that I feel makes sense in this situation. I know you disagree with me on that, but feel free to do that. Okay, so you talked about this condition where a primary adjustment to transfer price made by the assessing officer has been accepted by the assessee. Now, you cannot thrust acceptance by force on the assessee. So one interpretation is that if an assessee disputes a primary adjustment, and which means that he has not accepted the AO's adjustment, then in that case a secondary adjustment will not trigger off. Let's say for instance the assessee goes from the officer to the tribunal, from the tribunal to the High Court, and High Court to the Supreme Court. If I take that interpretation, then until and unless the Supreme Court decides the matter on the primary adjustment, secondary adjustment has to be kept at abeyance. I do not think that that is the intent of the law, and I'll explain to you why. The law has defined what is called excess money. In all the countries that have secondary adjustment, there is no such concept called excess money. This whole notion of excess money means that the lawmakers want that the secondary adjustment is a money that is remitted back into India. There are exchange control angles to this as well, and there are exchange control angles because amongst all the countries that Ashutosh talked about the law that deals with secondary adjustment, there is only one country other than South Africa and China that is not an OECD country. That's Bulgaria. In other words, all the countries that have a concept of secondary adjustment are OECD countries other than Bulgaria, China and South Africa. China and South Africa, just like India, have exchange control regulations. So the lawmakers in all the three countries chose the concept of secondary adjustment in their domestic law to compel foreign aids to remit the money back to India in the event there is a primary adjustment in India. If that is the underlying intent of the law, first of all, it doesn't align to the OECD concept of secondary adjustment. Two, then in that case what we are saying is that let's bring out a change in the income tax law by way of a secondary adjustment which will compel foreign associated enterprises to remit money into India to the extent of secondary adjustment. Okay, so two possible interpretations, but the way I read this is made by the assessing officer has been accepted by the SSC, which means that once the assessing officer makes the adjustment, it automatically triggers off a secondary adjustment, and if you do not trigger off a secondary adjustment, then in that situation there would be a rate of return on the loan transaction which will be carried out as an adjustment. That's my view. I know it's a conservative view, but that's how I have read the law, given the purpose behind why we had interpreted the law. I will just make one last point on the purpose of the law. If you read the memorandum to the Finance Bill of 2016, the government has made references to two aspects. Number one, this is a concept that is prevalent in the OECD guidelines, which is correct. And this was a reference that Mr. Dixit made earlier, that that the OECD guidelines has a concept of secondary adjustment. Second, they have also made a reference that there are many countries that have internationally accepted the concept of secondary adjustment. Now, both of these objectives don't translate into what the law is talking about, because bear in mind that the OECD concept of secondary adjustment is contained in the chapter on administrative approaches to resolve dispute. It is not contained in the chapter on resolving disputes or carrying out economic adjustments such that the books of accounts of the SSC in India and the foreign AE match. So what we are seeing now is a situation where the lawmakers are proposing to legislate secondary adjustment based on the intent that has been stated in the explanatory memorandum. But if you read it with the definition of the term excess money and what seems to be an underlying intent of the lawmakers to remit the money into India, there is a conflict that is occurring over here. And I feel it's the latter interpretation, that we need to get this excess money remitted into India, which is driving the lawmakers in India, and hence it departs from what has been stated in the explanatory memorandum.
Okay, so that's as you mentioned earlier, one view, and I would say that yes, if you go by the strict reading of the way the law is worded, it says made by the assessing officer has been accepted. I think maybe as we were debating internally also, when we were talking about this question, if the word and is interposed between made by the assessing officer and has been accepted by the assessee is inserted, it would kind of, go away from the view that secondary adjustment has to be made in all cases where a primary adjustment has been made by the AO. So this is again a point of representation that we may need to make, but there is definitely ambiguity on this, and in the interest of time, I will of course move ahead. The next question is really, what happens if a secondary adjustment is made and if the appellate authority partially upholds the primary adjustment and the assessee accepts it without further appeal, really. This is slightly simpler to answer, and I'll just take that. Really, there are no express provisions made in this regard, but the secondary adjustment, however, can be made in respect of a revised primary adjustment after giving effect to the order of the appellate authority. So what we are really saying here is that, once an adjustment has been upheld by the tribunal and an order giving effect has been passed by the assessing officer, for that primary adjustment, a secondary adjustment would trigger in. The next question is really also, an important question, which is really as to when is the secondary adjustment required to be made in case an assessee accepts a primary adjustment at a later point in time after assessment or an appeal. So, yeah, this is of course assuming a situation that we go with the view that a secondary adjustment needs to be made only once finality is reached. So once finality is reached in a particular appellate process and an assessee accepts the position of the appellate authority, then that is the timing when an adjustment is required to be made, and the law gives really two options to the assessee. It says that you can either bring in this excess money into India and then record this in the books of the assessee as well as the AE, or you could treat it as a deemed loan. So the secondary adjustment needs to be made in the assessment here when the primary adjustment fructifies. That's the first point. And if you decide to bring in the money to India, then you need to record this in your books of accounts. And what would be important to understand here is how and what entry would you pass in your books of accounts, because with the new Ind AS provisions where you don't have the concept of recording a prior period income or item, essentially this would become, something like other income in the year in which you're recording this. And it would also be difficult to force the AE to open his books of accounts. So, we would definitely need to make a representation here to see, how the law can really mandate, the AE to make a provision in his books of accounts. But again, here my view is that considering that the law gives you an option, really if that's not practically possible, then you have the second option where you can treat it as a deemed loan. And that is why also I think it converges into the fact, there are these practical difficulties why most of the countries have followed a deemed dividend approach. Because in a deemed loan situation, you would have to treat this as a loan from the year in which the transaction occurred. And therefore you would have an interest computation from that year. And if you don't bring in the money, there would be an interest on interest and it would be a perennial adjustment, right? So which is why I think most of the countries have preferred a deemed dividend approach, where it's a one-time secondary adjustment that you make in the year the primary adjustment fructifies. So this is again something that the government needs to think about as to, what are the practical possibilities of adopting a deemed loan approach in situation like our country where you have FEMA, you have indirect tax and you have Ind AS provisions and you need to marry all of them together. So moving on to slide 18. The first question on slide 18 is really, would the effect of a secondary adjustment be prospective or retrospective? Now really, this is an interesting thing. So let's take an example that there is a primary adjustment, say for assessment year 13-14, which is pertaining to a prior year, it exceeds 1 crore. The assessee goes up into appeals, and let's assume at the tribunal stage, the assessee loses and the TPO's order is upheld by the tribunal. The assessee therefore, and let's say the tribunal decision comes out in, financial year 17-18. Which is where the year from when a secondary adjustment kicks in. Then what is the timing from when this secondary adjustment will be effective. So the way it reads is that if you don't bring in the money into India, then you will need to treat this as a deemed loan from the year in which the international transaction has taken place. Therefore, the time period from AY 13-14 to 17-18 is the time period that you would take and compute interest and pay tax on that interest in your return of income. What is not clear in the current provisions is that would there be an interest on the tax liability which has been delayed, your interest under 234BC, and I would believe or want to believe and want to make representation to the government to say that that interest should not be levied, because really the secondary adjustment liability crystallizes only in assessment year or in financial year 17-18, and therefore there should be no question of interest on tax. But this is again a point of representation and clarification, that we would be seeking from the government. Now moving on to the next question, which really, again bases the practical experience of dealing with situations, I would like Mukesh to really answer, is what happens in a situation where you have defended your transfer pricing on an aggregated TNMM basis and there is a primary adjustment. So, how would you apportion the secondary adjustment to the various AEs? And what would be, Mukesh, your thoughts on this particular issue?
Thanks, Karishma. Well, first thing I wanted to say is that there is already a lot of interpretation that's available based on tribunal decision that the term associated enterprise includes the term associated enterprises. That's the first point I wanted to make. And why do I make this point? And I can possibly illustrate it by saying that let's assume there is an Indian SSE that receives intra-group services from 5 foreign different associated enterprises. And let's assume that there is an adjustment carried out vis-a-vis all the 5 enterprises. If there is an adjustment carried out vis-a-vis all the 5 enterprises, then it will automatically trigger off a secondary adjustment. And that would mean that all these 5 enterprises will have to remit money into India. And let's say for the purposes of this example, 2 enterprises don't remit the money to India. Then my view is that to the extent the 3 enterprises remit the money into India, there would be no adverse consequences. To the extent the 2 other enterprises which do not remit money into India, it would trigger off the secondary adjustment. And in order for me to support this argument, I'd like to again put emphasis on the term excess money. Excess money means the difference between the arm's length price determined in a primary adjustment and the price at which the international transaction has actually been undertaken. This definition of the term excess money has to be read with subsection 2. Subsection 2 says the excess money which is available with its associated enterprise, if not repatriated to India within the time as may be prescribed, shall be deemed to be an advance. The word available with its associated enterprise would mean available with its associated enterprises. So in this example that I talked about, where there is an intra-group services rendered by 5 entities, there is an adjustment and 2 entities do not remit the excess money, there will be pro rata adjustment on those 2 entities.
Sure. Thanks, Mukesh. Moving on, the next question really is, what happens when an assessee makes a secondary adjustment, really the amount of secondary adjustment made in the books of accounts and not realized within the reasonable time by the assessee would need to be considered as an advance. So this is a simple one. Is there a time limit prescribed for making the secondary adjustment? Currently, there is no time limit prescribed. However, it would be prescribed by the CBDT as per, section 92 CE subclause 2. The rules would kind of define that. The next question really, which is on the same slide, page 18, again is a very interesting question in terms of, in light of the recent controversies that we've had in the case of instrumentarium on, secondary adjustments. Would a corresponding adjustment be available to the A's in respect of the secondary adjustments? So Mukesh, what's your thought on this,
Karishma, can you repeat the question?
You have a situation like in instrumentarium, where an adjustment is made, would you get a corresponding adjustment in the A's where there is a secondary adjustment?
Yeah. Well, firstly, we have to differentiate between the two terms, secondary adjustment as envisaged under the Income Tax Act and corresponding adjustment. The word corresponding adjustment is used in the treaty and it's used in the OECD Model Convention, and the context to that is an adjustment under Article 9(2). So the concept of corresponding adjustment is different than the concept of secondary adjustment. Secondary adjustment mandates you to bring the money into the country in which a primary adjustment has been undertaken, whereas the corresponding adjustment is the adjustment under Article 9(2), which is given by the competent authority only under the MAP process. Now what this really means is that if there is a primary adjustment in India which now will result into automatically a secondary adjustment, and the taxpayer wants to look at disputing a primary adjustment, very often the taxpayer files the administrative appeal because there is a statute of limitation for filing the administrative appeal, but it actually would wait to file the MAP process because the MAP has a deadline of 3 years. Now what the secondary adjustment law is going to do is force the taxpayer to evaluate the filing and determine the timing of MAP rather than waiting for a 3-year period.
Sure. So I think that's interesting observation, Mukesh, because generally people tend to wait to put in their maps to see how the appeals are progressing, and therefore in light of the secondary adjustments, really what you're saying is, one should really consider preponing the MAP decision and evaluation at a much earlier stage so that you don't miss out on the time window. And of course, another point that I have here is that, one can also, once of course the multilaterals are signed and, Article 9(2) are triggered in most countries, I think, to avoid a secondary adjustment situation, looking at the complexity of the case and the litigation, the taxpayer could also evaluate a bilateral APA as an option more than the unilateral. We are really running against time, so I will skip the next two questions, but we would be circulating a technical question answer paper, post our webinar, which would cover most of these questions. And you can also write in to us for any further questions. Just in the interest of time, I'm moving ahead to the practical illustrations. And the first illustration that I've taken is really the majority scenario, which most of the companies in India would be, where an Indian company is rendering services on a cost plus basis. And let's say in this situation, the Indian company also is paying a management fee to its Singapore entity. Now, if the cost plus markup is at arm's length and there is no adjustment on that leg, but the TPO disallows the management fee on the Singapore leg, then the question is really that despite the fact that the Indian company would have got the cost plus, which is including the management cost from its parent company repatriated into India as a part of cost plus, will a secondary adjustment be triggered on the primary adjustment leg between India and Singapore? The way the sections are worded currently, I would tend to think yes, because that's a separate leg of primary adjustment that the TPO is dealing with. And if this management fee is disallowed, that means an excess amount is lying with the Singapore entity, and therefore that will need to be repatriated to India. And this would essentially mean that India has got this cost with a markup from its US parent, and now as a part of the secondary adjustment will also be getting this from the Singapore AE, So these kind of situations again could lead to a double repatriation into India, and will have to be considered by the government. The second question on this illustration or the thought that I want to leave with the participants here is that often there are a lot of adjustments on the cost base that the taxpayer makes in their tax return, like the free of cost assets or ESOP cost. It would be more prudent now going forward to make this adjustment in your books of accounts rather than in the return, because you would otherwise have to have a secondary adjustment impact if you're doing this suo motu in the return, and at the same time you won't get a corresponding deduction of this amount in the books in the hands of your AE. The next illustration is in an APS scenario, where really the question that, we are pondering on is that let's say the APA is signed after 1st April 2017, because the primary adjustments section, the secondary adjustment section kicks in after 1st April 17. But the APA has a rollback period. Now, will the secondary adjustment be applicable to the rollback period? The strict technical interpretation, as we debated a while back, the answer would be yes. But however, the intent is not to apply this retrospectively, and therefore it would be interesting to see what is the position that the APA authorities are taking. In the APA that we are dealing with, currently, anyways in the rollback period, what the APA authorities are doing is there is an option where if for any reasons, the taxpayer cannot bring in the money into India, then let's say you are at a cost plus 17 or 18 that's agreed in the APA authorities gross this markup to the extent of the dividend distribution tax and allow you to pay tax on this additional markup rather than bringing in the money into India. Now, with the secondary adjustment provisions coming in, I'm not very sure whether the APA authority will be able to give this option to the taxpayer, and therefore, one will have to deal with this in the APA scenario as well. Finally, to conclude on secondary adjustments, the way forward really is the government definitely needs to consider providing all three options as suggested by the OECD to the assessee rather than going only by the deemed loan approach. Second, make the language really clear to apply this prospectively. Third, they need to factor in the congruency with the FEMA, IDT and Ind AS provisions. Fourth, the timing then they need to clarify on the timing in terms of when the tax liability would accrue. And last, which is most important, is need to rethink on whether they can have a provision to mandate an entry in the books of the AEs. So we are, as BMR Advisors, making representation to the government on various points, and these we thought are the crucial points. And if you think there are any more points that you would like us to represent, please feel free to write to us. As a taxpayer, you definitely need to watch out for this provision on secondary adjustment from your FIN 48 perspective. So if you have provided for primary adjustments in your FIN 48 computations, then you cannot avoid providing for a secondary adjustment, because if you have taken a more likely than not possibility in your FIN 48 for your primary adjustment, then that will also be applicable for a secondary adjustment. In M&A transactions and deals also, when the buying entity is, having an indemnity on, or there are, negotiations on who should bear the tax cost for the previous year's provisions, this could be an important aspect to consider. As we just discussed, consider MAP and bilateral APAs. And most importantly, I think one needs to move out from making a suo motu adjustment and planning the transfer prices and closing that out before really closing your books of accounts. So that, if at all you need to make any adjustments on transfer pricing, then, you do that prior to closing your books of accounts. So this is all that we have from our end on secondary adjustments, and we will of course write in with our detailed paper to you all as well. Moving on to the next provision that the finance bill proposed to introduce is the interest deduction limitation. We are just going to briefly touch upon this, and I will request Mr. Dixit to take us through these provisions very briefly.
Thank you, Karishma. And as you mentioned, based on what time we have currently, we would be proposing a second webinar on the thin capitalization provisions, because they do need to be considered in detail. And the background to the thin capitalization provisions is actually Action 4 of the BEPS report. Again, there it talks about the fact that multinational groups can use intergroup loans or intergroup debt to trigger interest payments, and those interest payments go to reduce the overall tax liability of the group. And in many cases, those intergroup interest payments may exceed the interest which the M&E group as a whole is paying on third-party loans. And traditionally, thin capitalization provisions have been there in a number of jurisdictions. The last I saw, they are currently prevalent in around 60-odd jurisdictions. The finance bill proposes this thin capitalization provision in the Income Tax Act too. The way it's been proposed under the Income Tax Act is that if we go back to the arm's length principle, then the interest which you pay to the associated entity, that is currently covered under the arm's length principle. But there is no restriction under transfer pricing current provisions regarding the quantum of debt which you can take from an associated party. Now, what the thin capitalization provisions which have been proposed in the finance bill, what they do is that they seek to cap the interest which you can pay to an associated party based on a particular ratio, which includes the interest which you are paying to third parties. So briefly, how does it go? First of all, there is a de minimis provision which essentially says is that, number one, you have to have paid interest in excess of 10 million INR to an associated enterprise, to an associated entity. Now, once you have done that, then you come under the provisions of the thin capitalization rules. What it then says is that you will have to compute your earnings before interest, tax, depreciation and amortization, so EBITDA. On that, you will first take what is your total interest payment. If the total interest payment is in excess of 30% of EBITDA, so that then the excess portion is one part. The second part is the total interest which you have paid to your associated entity, and then you compare this. You compare the excess interest which you have paid in excess of 30% of EBITDA with the interest which you have paid to your associated party, and then the lower of the two is what is disallowed. It is not disallowed in the sense that you will never be able to take it as a deduction, but it is disallowed in that particular assessment year, but you are allowed to carry it forward to 8 subsequent assessment years. So essentially, if you see what it is doing, it is in a way restricting the quantum of interest which is also payable to an associated entity. Besides the rate of interest which is under an arm's length principle, it is also saying is that the quantum of interest which you can pay to an associated entity, that also needs to be restricted, and restricted to the extent as provided in this thin capitalization provisions and as I have described. Now briefly, if I look at it in terms of a global practice, as I said, this is actually prevalent in 60 odd countries, but the way it has been worded in the Indian provisions is very close to what it is there in Norway and in Finland, because in a number of countries the thin capitalization rule is actually triggered off as soon as you are in excess of 30% or 10% or 20% of EBITDA, depending on that legislation. But then once you are in excess of it, what is disallowed is the entire expense, irrespective of whether it is to an associated entity interest or to a third party. So that basically is it's a very major change in the provisions under the Income Tax Act. A number of capitalization decisions and debt equity decisions for taxpayers will need to be reviewed based on what is the final provisions under the Income Tax Act as it gets legislated through the Finance Act. And I'll close my comments on this right now in the interest of time, and I'll hand this back to Mukesh for you.
Thanks, Ashutosh. Well, we kind of anticipated that there would be several questions on this important change, and that's why we ran it in the FAQ format. The reason we have kind of blown up our time schedule is because most of the questions that we envisaged at the FAQ level were actually raised by participants in the webinar today. So, you know, the only conclusion I can draw is that participants are as smart as professionals. There are a couple of questions I wanted to take which did not feature in the FAQ. I will take those very quickly. The first question is, should excess money be not reduced by tax payable on primary adjustment? Well, this question is academic because if you pay the tax, then the primary adjustment has been accepted by the taxpayer. And once you accept it by the taxpayer, it will consequentially result in a secondary adjustment, and hence this is, in my view, academic. So if you pay the tax for a part of the money, then it will apply only for the part of the adjustment that has been accepted. The second question is that what happens if an Indian company borrows at 10% and makes withholding tax accordingly, and the primary adjustment suggests that the arm's length price is 8% and the excess money is received back because the 2% that has been subjected to the transfer pricing adjustment, which becomes a secondary adjustment, has to be remitted back. The question is, will the excess withholding tax paid on 10%, which is the transaction price, be refunded? My answer to this is that it will not be refunded, because a secondary adjustment is nothing but an anti-avoidance provision. So since the SSC erred in carrying out the correct arm's length price and subsequently the tax authorities adjusted the arm's length price, it is resulting in that income getting taxed economically twice, and the only resort that the taxpayer will have is by way of adjustment under the mutual agreement procedure and not under the domestic law. So insofar as the secondary adjustment provisions under the Indian statute is concerned, it will result in taxation twice. With that, we've really come to the end of the presentation, but before I say thanks to everyone, just a couple of announcements. This recorded presentation will be uploaded on the YouTube. You can access it. In addition, the BMR Insights, which is the app, will also carry the PowerPoint presentation. You will be able to access the presentation also through the firm's Twitter handle, which is at BMR Advisors. So with that, thank you very much for your participation, and we look forward to receiving your questions that will just help us present scenarios to the Ministry of Finance at the time when we are seeking appropriate changes before the finance bill is moved or for that matter appropriate administrative changes which will come by way of a subordinate legislation. Thank you very much, ladies and gentlemen, and watch the BMR space for our next webinar which is on thin capitalization norms. Good day. Thank you very much.